Hello and welcome to Law Books Simplified, and here we are doing the simplification of the book Code of Civil Procedure by C.K. Takwani, and we'll go to every line of every paragraph of every single page of this book, and I'll try to explain them as easily as possible to make it a little more interesting to you. And today we're going to start the second chapter of the introduction part, that is important definitions. So without any further delay, let's start. In most of the statutes, a section provides for definition of some important expressions used in the body of the act. The definition clause is a sort of statutory dictionary, a legislative device with a view to avoid making different provisions of a statutory needlessly cumbersome. Where a word is defined in a statute and that word is used in a provision to which that definition is applicable, the effect is that wherever the word is defined is used in that provision, the definition of the word gets substituted. This normal rule may be departed from it if there be something in the context to show that the definition should not be applied, or when the context strongly suggests its departure. So as we know that like in every act or every codified laws, there is the section in mainly the section 2 that is that contains the definitions of certain words, certain key phrases which are to be used in the provisions for the provisions, and those words are very tricky. They mean something specifically in those provisions. So in the first part of this video we'll be doing the decree and its meaning. So let's move forward to it. The decree, it's adjudications of court of law, and it may be divided to two parts. The first part is the decrees, and the second part is orders. The adjudication of court, they can be divided into two parts. Any adjudication where they are discussing the rights and liabilities of parties, there has to be two parts, and the first one is the decrees and the second one is the orders. Section 2, subsection 2 of the code defines the term decree in the following words. Decree means the formal expression of an adjudication which, so far as regards the courts expressing it, conclusively determines the rights of parties with regard to all or any of the matters in controversy in the suit, and may be either preliminary or final. It shall be deemed to include the rejection of a plaint, and the determination of any question within section 144 shall not include a. The adjudication from which an appeal lies is an appeal from an order or any order of dismissal for default. So in this definition we find some key words like formal expression, adjudication, conclusively determines the rights of the parties, and it regards with the matters that controversies in the suit. So these key phrases will be discussed in further discussion of this video. And one thing that to be kept in mind, that decree is not something that is order. If a decree lies in appeal in a form of order, that will be not considered as a decree. Or if a suit is dismissed on the first pleading, on the default, if it is dismissed, then that will not be considered as a decree. So before going to further discussions, I would like to know the concept of decree. That is, it is a formal adjudication of a matter where it determines the rights of a party, but not maybe conclusively or maybe partly, and it has to be in a suit. And what it does, it is a conclusive determination. The partly determination which I said, it is considered with the preliminary decree, which also determines conclusively that particular thing. So we will discuss that further again. So let's move to the essential elements. The first essential element is there must be an adjudication. Such adjudication must have been done in a suit. It must, number 3, it must determine the rights of the parties with regard to all or any of the matters in controversy of the suit. Number 4, such determination must be of a conclusive nature. Number 5, there must be a formal expression of such adjudication. So what we find first is there has to be an adjudication. So what is adjudication? For a discussion, for a decision of a court to be a decree, there must be an adjudication, that is, a judicial determination of the matter in dispute. If there is no judicial determination of the matter in dispute, it is not a decree. Thus, a decision on a matter of administrative nature, or an order dismissing a suit for default of appearances or parties, or dismissing an appeal for want of prosecution, cannot be termed as a decree, inasmuch as it does not judicially deal with the matter in dispute. Further, such judicial determination must be by a court. Thus, an order passed by an officer who is not a court is not a decree. So in the first essential element of decree, it says that there has to be an adjudication. An adjudication is a judicial determination of a certain judicial matter. Now, if there is no adjudication, if there is no judicial determination, or any determination which is not done by any judicial authority, that will not be termed as a decree, because a decree has to be made by any judicial authority acting on the scope of that particular case came in front of the judicial authority, and that determines something which becomes an adjudication, and decree lies from that adjudication. And one thing has to be kept in mind, that if anyone orders something, and that figure is not a judicial body, that will not be considered as an adjudication. So moving on to the second essential element, that is suit. The expression suit is not defined in the code, but in Hansraj Gupta versus Official Liquidators of Dehradun Mussoorie Electric Tramway Company Limited, their Lordships of Privy Council has defined the term in the following words. The word suit ordinarily means, and apart from some context, must be taken to mean a civil proceeding instituted by the presentation of a plaint. Thus, every suit is instituted by the presentation of a plaint. It means that when there is no civil suit, there is no decree. Thus, rejection of an application for leave to sue in forma pauperis is not a decree, as there is no plaint till the application is granted. So it says that, like adjudication, there has to be a suit, and without any suit there cannot be any decree. So to form a decree, there has to be an adjudication in form of a suit. And as instance here is given an example, that a rejection of a leave to sue by a pauper, that cannot be termed as a decree, because the case was not filed, no plaint was accepted by the court. Normally a civil suit is started by a plaint, but if there is no plaint accepted by the court, there is no civil suit, and without any civil suit there cannot be a decree. Moving forward, it may however be noted that under certain circumstances, specific provisions have been made to treat applications as suits. Examples: proceeding under Indian Succession Act, the Hindu Marriage Act, the Land Acquisition Act, the Arbitration Act, etc. They are statutory suits, and the decisions given thereunder are therefore decrees. Therefore, a proceeding which does not commence with a plaint and which is not treated as a suit under any other act cannot be said to be a suit under the court also, and the decision given therein cannot be said to be a decree under section 2 subsection 2 of the court. Thus, a decision of a tribunal, even though described as a decree under the act, is a decree passed by a tribunal and not by a and that is not covered by section 2.2. So it says that a decree has to be made from a judicial authority, and and there are certain acts by which a decree can be formed, and even without a plaint. Those are Indian Succession Act, Hindu Marriage Act, Land Acquisition Act. But one thing has to be kept in mind, that a decree or a decision given by a tribunal, that cannot be termed as a decree under section 2.2, because that is not coming from a judicial authority in a suit. So moving forward, rights of parties in controversy. The another phrase we get from the definition from section 2 subsection 2. Rights of parties in controversy. Decree can be given to the rights of the parties in controversy only, and not to any other person. So let's go through it. The adjudication must determine the rights of the parties with regard to all or any of the matters in controversy in the suit. The word rights means substantive right of the controversy in the suit. The word right means substantive right of the party and not merely procedural rights. Thus, rights of the parties inter se relating to status, limitation, jurisdiction, frame of suit, accounts, etc. are rights of parties. Under this section, the rights in matters of procedure are not included in it. Thus, an order for dismissal of a suit for default of appearance, or an order dismissing an appeal for execution of non-prosecution, or an order refusing leave to sue in forma pauperis, or mere right to sue are not decrees, as they do not determine the rights of the parties. So it says that, as we have discussed before, the rights of the parties must be discussed in the decree. If a decree is passed with and that conveys no rights, that will not be treated as a decree. And it says very specifically here that the rights and the matters of the procedure are not included in it. If they are, then that will not be considered as a decree. Again, the same example I would like to use here, that for leave to sue appeal by a pauper, a poor man, that appeal is rejected, and that will not be considered, that rejection will be not considered as a decree, because there is no right is determined. Moving on, the term parties means parties to the suit, that is plaintiff and the defendant. Thus, an order on an application by third party who is stranger to the suit is not a decree. As we have just discussed before, that decree can be given to the parties in the controversy only. In interpleader suits, the contesting defendants will be deemed to be parties to the suit. The expression matters in controversy refers to the subject matter of the suit with reference to which some relief is sought. At the same time, however, it should not be understood as relating solely to the merits of the case. It would cover any question relating to the character and status of parties suing, to the jurisdiction of the court, to the maintainability of a suit, and to other preliminary matters which necessitate an adjudication before the suit is inquired into. Interlocutory orders on matters of procedure which do not decide the substantive rights of the parties are not decrees. Similarly, the proceedings preliminary to the institution for a suit will also not be included in the definition. So it just widens the scope of the definition, and by saying that which matters will not be termed as decrees. By example, again, the interlocutory orders that does not define any rights of any parties, or proceedings where the preliminary to the institutions, that the filing of the suit, that plaintiff is rejected, the written statement is not filed, those things, that part the suit is not even in motion, those things will not be considered as a decree. And the fourth one is conclusive determination. Such determination must be of a conclusive nature. In other words, the determination must be final and conclusive as regards the court which passes it. Thus, an interlocutory order which does not decide the rights of the parties finally is not a decree. Example: an order refusing an adjournment or an order striking out defense of a tenant under relevant rent act, or an order passed by appellate court deciding some issues and remitting other issues to the trial court for determination under order 41 rule 23 of the code, are not decrees because they do not decide rights of the parties conclusively. Again, the same thing is repeated, that the rights of the parties has to be decided. If it is any adjudication by any act like the relevant rent act or anything, if the rights of the parties are not being decided, that will be not considered as a decree. On the other hand, an order may determine conclusively the rights of the parties, although it may dispose of the suit. Thus, the order dismissing an appeal summary under order 41 of the court, or holding it to be not maintainable, or decision dismissing a suit for want of evidence or proof, are decrees inasmuch as they decide conclusively the right of the parties. So here is our interesting and tricky part, that under order 41 of the court, or holding it to be not maintainable for a decision dismissing a suit for want of evidence or proof, are decrees. So these orders are decrees, and some orders are not decrees. So how will we decide if some order is decree or not? If that determines the right of the parties in the controversy. So here it determines, order 41 determines the rights of the parties in the controversy, so that will be deemed as a decree. The crucial point which requires to be decided in such a case is whether the decision is final and conclusive in essence and substance. If it is a decree. If not, it is not a decree. So moving on to formal expression. There must be a formal expression of such adjudication. All the requirements of form must be complied with. The formal expression must be deliberate and given to the manner provided by the law. The decree follows the judgment and must be drawn up separately. Thus, a decree is not formally drawn up in terms of judgment, no form. Thus, a misdescription of decision as an order which amounts to a decree does not make it less than a decree. So, another thing that is very, very important to remember, that it must be a formal expression, and that adjudication from which the formal expression is being squeezed, it should be complied with all the requirements of a decree. All the procedures must be followed of announcing that decree. The decree must follow the judgment, and that decree has to be treated separately. So it has to be a formal expression for a valid decree. So this is it for this video, and on the next video we'll do the test and we'll see which orders are decrees, which decisions are not or decrees but orders and all. And if you have any problems regarding this, please comment on the comment section. I'll try to solve them as soon as possible, and do subscribe, and thank you. Have a good day.